Dear students, today I am going to tell you about law of will or Wasiyat under Muslim law. Wasiyat or will offers to the testator a means to change the course of inheritance to a certain extent and to recognize the value of those relatives who are excluded from inheritance or strangers who might have helped him in life or in last moments. Under Muslim law, the law of inheritance is based on the verses of the Quran, and therefore, for Muslims, the laws of inheritance are settled and they cannot be changed. However, will or power to make a will gives him the opportunity to make certain changes. Therefore, to some extent, the power to make a will gives an opportunity to the testator, that means the person who makes the will, to bring about to make certain changes. And that is why some power has been given under the law of will. We will study those things in detail as we will proceed. Now let us first of all try to understand if there is any possible definition of will. Tayyib defines, and his definition is based on Indian Succession Act 1925. He says, a will is a legal declaration. It is a legal declaration of the intentions of a Muslim with respect to his property, which he desires to be carried into effect after his death. Meaning, thereby, will is a declaration, and that declaration is a legal declaration by a Muslim. This declaration makes clear about his intentions with respect to his property, which he desires to be carried into effect after his death. This is the simplest possible definition. The law of will has a very strong connection with a famous hadith. In this hadith, which was narrated by one of the companions of Prophet, peace be upon him, whose name was Sa'd ibn Abi Waqqas. Sa'd ibn Abi Waqqas said, he narrated, that once he was ill, he was bedridden, and he thought that probably he's going to die. Prophet Muhammad, peace be upon him, visited him. Sa'd ibn Abi Waqqas asked Prophet about making will. He said that I have huge amount of wealth and I have only one daughter who is also rich. I want to make a will for religious and good purposes, and I want to give away my entire property by way of will. Can I do so? Prophet, peace be upon him, said no. Then Saad kept on reducing the quantum of the property. He said, can I make a will in respect of two-thirds of my property? Prophet again said no. Then he said, can I make a will in respect of half of my property? Prophet again said no. Then he said, can I make a will in respect of one-third of my property? Then Prophet, peace be upon him, said, yes, you can do so. Give this much of property by way of will to anyone whom you desire, And he said that it is better to leave your heirs, your relatives, your descendants rich than leaving them poor. So, from this hadith, which is a very important source of Muslim law of will or wasiyat, all schools of Muslim law recognize this hadith, and under all schools, including Shia and Sunni schools, this rule of one third, this limitation of one third of property for the sake of will came into existence. So, under Muslim law, a Muslim can generally make a will of the one third of his net asset, of the total property he has. This rule has been interpreted in such a way that all the schools recognize it. Now, a question arises: how does a Muslim make a will? What is the formality? What is the form of the will? So, the answer is it may be made orally or in writing. So, as far as the form of making will is concerned, it can be made orally as well as in writing. So, both ways. I mean, it can be made orally also, it can be made in writing also. But the convenience demands that it should be in writing. Because if it is in writing, there will be evidence of the will. But law says that if it is in writing, it need not be signed. If signed, it need not be attested. The only requisite is that the intention of the testator should be clear. So even if it is oral will, the intention of the testator should be clear. And so is the case if it in a situation where the will is in writing. So much so that even a dumb person or a person who is unable to speak due to illness may make a valid will through gestures, if his gestures can be read clearly. Now the question rises: who can make a will? Who has the power to make a will? The answer is a Muslim who is major and of sound mind. Obviously, when we are studying Muslim law, we are studying these provisions under Muslim law. Therefore, the person who is making a will, who is also known as testator, should be a Muslim. It goes without saying. He should be major also, and he should be of unsound mind. A person of unsound mind is not competent to make a will, and a will made by such a person is invalid. A will made by a person while of sound mind, who later becomes of unsound mind before his death, becomes invalid. This means that a person, while when he was making will, he was of sound mind. But later on, he became a person of unsound mind. And he remained so till his death. So his will, which he had made when he was of sound mind, that will becomes invalid. This means that for making such a will valid, the person should be of sound mind at the time of death. Now, a very curious question arises, and that is what will happen if the person who has made a will commits suicide? What will happen to the validity of a will made by such a person who committed suicide? The answer is that under Sunni law, the will of a person made just before committing suicide is valid. Sunni law treats that even if a will has been made by a person who ended his life on his own, he committed suicide, the will is valid. But Shia law says that if a, if a person executes any will after attempting to commit suicide, the will is void. What does it mean? It means that the person did something because he wanted to kill himself. Suppose he consumed poison. And after consuming poison, in haste, he started writing his will. And finally, he died. What will happen to the validity of such a will? The answer is that such a will under Shia law is void. But under Sunni law, it is valid. If a minor makes a will, what will happen to the validity of such a will? It is void. Minor's will is void unless ratified by him after attaining majority. So if after attaining majority, the will has been ratified by that person who is now major, the will becomes valid. But if he does not ratify, any will made by him during his minority is void. Now, there are some other questions, very important questions related with the law of will. And these questions are: what can be bequeathed? And how much can be bequeathed? That means, what should be the subject matter of will? What can be given away through will? And how much can be given through will? Now, these two questions should be understood patiently. As far as the question of subject matter is concerned, what can be given? The answer is both the corpus of the property and the usufruct of the property can be a subject matter of will. And the third thing is also there, which is known as vested remainder. Corpus of the property means the physical existence of the property. In Hindi, we call it काय, संपत्ति का काय. We know that there are certain properties which are tangible. Tangible properties have their physical existence. Suppose there is a building. A is the owner. A wants to give away that building to his friend, to his relative, through a will. And he writes a will to this effect, gives away that building in favor of his friend or relative. So what did he give? He gave the corpus of the property, corpus of the building. Its physical existence was given away. But usufruct, when somebody gives usufruct of the property, in that situation, it is not the corpus which is given. It is only the right to use, right to get the benefit of that property is given. So, when corpus of the property is given, it should be in existence at the time of testator's death. And when usufruct is given by way of will, it can be given for a limited period of time. Vested remainder is a third thing. Vested remainder is, suppose A makes a will of his land in such a way that he gives the corpus to B and the usufruct for 10 years to C. What will the effect of such a will? Both the wills are valid. B will get the corpus, but C will get usufruct for 10 years only. When 10 years will pass, when 10 years will end, then B will get everything, both the corpus and the right to use that property, the usufruct of that property. This is called the vested remainder. Finally, B will get everything, the corpus as well as the usufruct, which is the right to use that property. He will get the benefit of that property also. This is the vested remainder. Now, a pertinent question is how much of the property can be bequeathed? That means how much of the property can be given away by way of will? Under other personal laws, Hindu law and other laws, a testator, a person who is making a will, can give away his entire property through will to anyone, whether his heir, or non heirs. But Muslim law puts two restrictions. Remember, under Muslim law also, a person can give away his entire property to somebody else through gift, through hiba, but not through will, generally. Because under will, there are so many restrictions. At least two restrictions are there on a Muslim. First restriction is there is a restriction upon the quantity of property bequeathed. The amount of the property. With respect to the amount of the property, there is one restriction. And the second is in respect of the person, that is the legatee, to whom the property is given. So there are two restrictions. Let us try to understand one by one. First, restriction upon the quantity of the property bequeathed. How much can be given? When a person dies, first of all, his funeral expenses and debts, if any, are satisfied out of the property left by him. This is a general rule that funeral expenses, and if he has any debts, the amount of the debt is satisfied, and then whatever is left for the heirs, successors. उत्तराधिकारियों के लिए वो प्रॉपर्टी रहती है. The property which remains after payment of funeral expenses and debts incurred by the deceased person is called net asset. Net asset. Out of this net asset, he can make a will of only 1/3, generally. This is the rule under Muslim law. Out of the net asset, he can make a will of 1/3 property. As I said, under other personal laws, the legator can make will for his entire property, but this is not generally possible under Muslim law. How much can he bequeath? 1/3 of his net asset. Now, the second restriction. And this restriction is with regard to the person in favor of whom a person can make a will under Muslim law. Now, let us try to understand one by one. With example, bequest to a stranger or a non-heir. Suppose a Muslim wants to make a will in favor of some stranger or a non-heir. Who is a stranger? The term stranger is being used here for those people who are not heirs of that person who is making the will. Anybody other than the heir is a stranger. What does the Muslim law say? A Muslim can make a will in favor of a stranger to the extent of 1/3 of the property. He can give away his property to anyone, any non-heir, to the extent of 1/3. For more than 1/3, if suppose he wants to give away more than 1/3, he has to obtain the consent of his own legal heirs. With the consent of his own legal heirs, he can give away more property. But to the extent of one third, he does not need any consent. But beyond one third, he needs the consent of his legal heirs. When a Muslim has no legal heirs at all, maybe suppose a person has no legal heirs. In that situation, he is entitled, he has the right to, to make a bequest of any amount of property to any stranger. He may give away the entire property when there is no heir. But generally, this does not happen. Everybody has some heir. So if he wants to make will in favor of a stranger, a non heir, he can do so to the extent of one third property, but beyond one third, he needs the consent of his own legal heirs. Suppose he wants to make will in favor of his own heir. What is the law in such a situation? The law says that irrespective of the quantity of property bequeathed, will to an heir of the testator is valid only if other heirs give their consent. So a Muslim cannot make a will generally in favor of his own heir. If he wants to do so, he needs the consent of other heirs. And subject to the approval of rest of the heirs, he can give property through will to any heir. So other heirs must give consent. Generally, a Muslim cannot make will in favor of his own heir. However, under Shia law, there is a difference. Shia law says that there is no difference between a bequest to an heir and a bequest to a non-heir. Bequest means will, Wasiyat. For Wasiyat, there are many terms which are used. For Wasiyat, we call will, we use the term bequest, we use the term legacy, we use the term testament. All these words are used for will or Wasiyat. So you should not be confused. So I was saying that there is no difference between a bequest to an heir and a bequest to a non-heir. A bequest to an heir up to one third is valid without the consent of remaining heirs under Shia law. The consent of other heirs is required only when the bequest exceeds one third of the property. So there is a difference between Sunni law and Shia law. This difference must be kept in mind. As far as the consent of heirs is concerned, this rule should also be remembered. Under Hanafi law, consent is valid if the heirs give their consent after the death of the testator. The consent which we were talking about just earlier. That consent under Hanafi law is valid if heirs give their consent after the death of the testator. But Shia law says that such consent can be taken either before or after the death. Doesn't matter. Consent has been obtained whether before the death of the testator or after the death of the testator. It makes no difference. Under Shia law, both have the same importance. However, under Sunni law, the consent of the heirs should be such that it has been obtained after the death of the testator. Now, in whose favor? For whom? Who can get the benefit? In whose favor a will can be made? This should also be understood point-wise. Number one, in favor of any person, male or female, Muslim or non-Muslim, doesn't matter. So a Muslim can make a will in favor of a male, in favor of a female, in favor of a Muslim, in favor of a non-Muslim. Doesn't matter, all are valid. Now the second example is, can a Muslim make a will in favor of an unborn person? A person who is unborn. Generally, he cannot make. Unborn person cannot be a legatee. The general rule is that. However, there is an exception. This exception has been explained by various authors. And I have taken this from the book of Fazi. And Fazi quotes Wilson and Tayyabji. And Fazi says that a will can validly be made to a child conceived so long as it is born within 6 months from the date of the will. And Fazi takes this opinion from Wilson and from Tayyabji. So, according to Fazi, in Sunni law, a will in favor of an unborn person is valid subject to two conditions. Number one, the child is in the mother's womb at the time of the will. When the will was being made, the child should be in the womb of the mother. And number two, the child is born within 6 months from the date of making of the will. Many authors on this point have written different things. But this point, which I have given here in this slide, I have given after consulting many writers. And that is why I have given reference of Fazi, Wilson, and Tayyabji. These two conditions should be remembered. Many writers have explained it differently. And when you read two books, you may get confused. One author writes one thing, the other author writes the other thing. But I have given the reference of some authorities. These authorities are recognized authorities, Fazi, Wilson, and Tayyabji. Their opinion I have mentioned here. In this situation, the opinion of Shia law is that the period is 10 months, not 6 months, which is the maximum period of gestation. Maximum period of gestation. Period of gestation is that period during which a child remains in the womb of the mother. That period is called gestation period. Now, heirs cannot be legatees, but this is only under Sunni law. Legal heirs cannot be. उत्तराधिकारी के पक्ष में वसीयत नहीं की जा सकती. But this rule applies only under Sunni law. According to Shia law, to the extent of 1/3 of the property, will can be made in favor of legal heirs also. What will happen? What is the answer when the legatee, that means the person in whose favor the will is made, if he himself causes the death of the testator, if he himself causes the death of the testator, what will happen? Will he get any property through the will of the testator? The situation is this: testator has made a will. In that will, he has given some property to a person. That person, that very person who has got some property in the will, he himself causes the death of the testator. What will happen? Sunni law says that the legatee will not get anything. He will not get anything if he has caused the death of the testator. But Shia law, especially the Isna Ashriya Shia law, says that he will not get anything if he has killed the testator intentionally. But if he has killed unintentionally, he will get the property. But if he has killed him intentionally, he will not get anything. On this point, Shia law appears to be more rational. As far as institutions are concerned, Muslim law says that in favor of institutions also, will can be made. The property can be transferred through will in favor of institutions also. Whether institutions are religious or charitable, they can be valid legatees in their favor. Will can be made. Through will, property can be transferred. Now, let us try to understand the kinds of bequest. Conditional, suppose there is a conditional bequest. If the bequest is conditional, the law says, Muslim law says, condition is void, but bequest is valid. Condition is void, but the bequest, that means wasiyat, will, is valid. If the bequest is, wasiyat is contingent, contingent bequest is void. What about future bequest? Future bequest means the bequest of a property which is expected to come into existence in future. Now, if the answer depends on the nature of the property. If the bequest of the if bequest is of the corpus, then it is void. But if it is of usufruct, right to use only, for a limited period, then it is valid. Now, fourth examples is of alternative bequest. If the bequest is alternative, I've given an example. Suppose A makes a will and he says that this property should go to my son if he is alive, otherwise to my grandson if he is alive, otherwise for charity. This is the example of alternative bequest. If the son is alive, he will get the property. If son is not alive, grandson is alive, then grandson will get the property. If neither the son nor the grandson is alive, then the property will go for charity. This is example of alternative gift. Muslim law says that alternative gift alternative bequest. And Muslim law says that alternative will or bequest is valid. So this is all which I wanted to tell you about the law relating to Wasiyat. Hope you have understood it. Please go through my videos and prepare for your examination. I hope you will perform well. I wish you all the best. Thank you. Thank you very much.